there are two issues that I want to deal with, even though we have passed the bill out of committee, that I think we need to address before we encourage and bring it up to the floor. One of those is limiting back the exemptions. What I would like you to do is as something that you would appreciate if you would really put some thought and brain power behind, is to get back to this committee in about a week's time. You've been looking at FOIA, you've spent time with FOIA, you've spent years looking at it. How would we reconstitute those 9? Should they be 3? Should they be 2? Should it be, maybe it's 18 and they just have to be much more specific? How would you take that section of FOIA and redo it in such a way that there are certain things, there are certain privacy things with individuals that have to be, I think we'd all agree about that, but I do hear this resounding drum beat that says it's being far too used. It's so liberal in its approach that you can put everything under there, and then you get what Ms. Mitchell here is binders full of redactions that, and we deal with this the same thing in Congress. I mean, even when we issue subpoenas, we get information that's so heavily redacted, it's ridiculous. So we would appreciate your thoughts and comments in writing back on that as we, at the staff level, in a bipartisan way, try to redo that. The other one that I'm struggling with a little bit, that I need your help and insight, and I appreciate some verbal comments, but again, give it a little bit of thought, is what is the consequence? Because if there are no consequences, now part of that can be who pays, but ultimately it's the taxpayers that end up paying, right? No skin off somebody's back if you got to pay. So, but there has got to be some degree of consequence for noncompliance, and for just running out the 20-day clock, they just blow right through that, and we're talking about years often for these materials. So, Ms. Garcia, I'm going to start with you because I can tell you're anxious to talk about that, and then Mr. Fitton too, if you could jump in here.
Thanks so much, Mr. Chairman. Actually, because I don't take these requests to court, I'm probably the most experienced in terms of securing compliance without that stick. The statute actually does provide for consequences to a FOIA officer. That's why every single decision has to be signed by an individual. It's often the case that, for instance, State Department is getting away with little initials so that you can't track down who the person was who made that decision. And then once it goes to court, which I never go to court and they know I don't go to court, but if you went to court, you couldn't really pin that back on one person. The statute does provide. Problem is, it gets triggered by the judge. The judge has to find that there was arbitrary or capricious or like just so outlandish. Guess how many times they've ever referred something to special counsel? 0. Big goose egg. In addition to that, because FOIA cases are decided at the litigation level, I know a lot about litigation only because that's the way I'm able to avoid it. But the fact is that it's a closed set, the FOIA request. So when it comes to a court, it's not like an unbounded discovery situation, typically. You could go there, but typically it's just the closed record that was before the agency at the time they made their decision and their appeal.
Okay, let me go to Mr. Rotman and then Ms. Mitchell and Mr. Fitton. And we have to keep going here. So yes, Mr. Rotman.
So I think that so fundamentally one of the primary issues that's happening with FOIA today is this question of secret law, and it goes to and it covers a lot of ground. Part of it is this deliberative process privilege, which is being used to keep what agencies are calling pre-decisional documents from the public, but those documents, for instance, will show internal dissent on questions that are of the utmost importance for public policy, and they'll actually contain documents that are binding on agencies. One of the other.
So let me just, because my time's expiring, and we're going to have votes, and we're going to get cut short. Ms. Mitchell here, consequence. How do you institute consequence for noncompliance?
Well, Mr. Chairman, I think that we should look at some of the states. The state of Florida has imposed criminal consequences for failure to abide by the state equivalent in Florida of their Freedom of Information Act, and there have been people prosecuted, and it has actually had the deterrent effect of making agency people realize that if there are consequences, they better follow the law.
Okay. Mr. Fitton?
Well, it's difficult to impose consequences on decisions that are discretionary, and that if a court disagrees, 2 people disagree. But if you eliminate the discretion, it's easier. But where you have this willful withholding of documents, there already is a law that could put you in jail for 3 years for unlawfully and willfully concealing records. And there's no limit as to how that could be applied. And of course, a change in procedure and a change in attitude and approach by the agency heads, by the political appointees that reward disclosure and punish the arbitrary or broad exemptions that are used where everything is withheld because it's deliberate process as opposed to a more careful analysis.
Thank you. I would like all of you to give you a chance to respond, but I'm a minute past my time here, so we got other members who'd like to ask questions. So now recognize Mr. Cummings for 5 minutes.